I find the need to draw the nation's attention to the serious violations of the Constitution and law in the process, and the danger it holds for the development of the nation's democracy. The second reason for making this statement is, though I'm in the process alone, its effects ripple far beyond me as a person. This process will affect how all Superior Court justices and future Chief Justices may be removed from office. It also affects commissioners and heads of independent constitutional bodies set up to protect the freedom and justice of Ghanaian citizens as guaranteed under the 1992 Constitution. In building Ghana's democracy in the Fourth Republic, the framers of the Constitution identified public officials who must directly serve the citizens of Ghana without being afraid of unjustified punishment or reprisals from influential people or members of the executive or legislature. Second, the petition itself has not been admitted into evidence and subjected to cross-examination by me or my lawyers. In this case, because they have permitted the petitioner who has so far given evidence of whose petition we are supposed to be dealing with, Mr. Daniel Ofori, they have permitted him not to testify and confirm on oath what his petition is. There is no petition on the table. There is no evidence given by him on oath. He has not authorized anyone to testify on his behalf. So what are we inquiring into? Even though there is no constitutional instrument passed to regulate the proceedings of an Article 146 committee, Ghana has a constitutional instrument regulating the work of all commissions or committees of inquiry. This is the Commissions of Inquiry Practice and Procedure Rules 2010, CI 65. And in Article 1467 of our Constitution, if a committee is set up for the removal of a Chief Justice, the committee is supposed to, quote-unquote, inquire into the petition, the answer, and the prima facie case. Therefore, we are dealing with a committee of inquiry. In spite of this, on 15th May, the committee decided, without listening to my lawyer, that to conduct the hearing as not as an inquiry, but as litigation. They refused to give me a copy of the prima facie determination that His Excellency the President is supposed to have given to them. They claim that they know that the President sent me copies on 27th March of the petition on 27th March 2025. And so they will not need to show me what the President gave to them. They also claim to have copies of the responses that I gave to the President, but they will not provide the petitioners with copies of my responses. The difficulty with this is, because they are the independent body charged with the duty to conduct the hearing, what I have in my hand from the President could be different from what they have. And I cannot assume that the two copies are the same. Indeed, no tribunal does that. No tribunal will tell you that before you came here, we know that your landlord wrote to you, so we are looking into what your landlord wrote to you about, and so that is what we will be inquiring into. They will give you what the charges are that they are supposed to be inquiring into.